All right. So we're gonna go over trust today. Um, the reason why is because we have quite a few trusts happening. It's a popular thing in some areas of the United States, and California is one of them, where people prefer to hold their properties and assets in a trust. So let's go over why understanding trust held property matters for real estate agents. Um, so trust sales are everywhere and they're growing. I know when I first started selling real estate, a little over 2 decades ago, this wasn't as much of a thing in my business back then. Now, being blessed to have this brokerage and seeing all of your guys' deals come through, I see a ton of trust sales. I mean, even in the past probably 5 to 10 years, I've seen a real uptick in, I guess, the ratio of trust sales that are coming through. So, why are people choosing them? It's homeowners use living trust to avoid probate. They want to keep privacy and they want to simplify transfers within their family and the beneficiaries. So this means more listings for you that you'll see titled as a trust, and the decision maker is a trustee, not an individual seller. So if we're fluent in the mechanics of a trust sale, basically who signs, what to collect, what to disclose, we can shorten timelines, reduce friction, and win listings against agents who just aren't sure. So uh, why else? They're faster than probate, but only if we do it right. Trust can move much faster than court supervised probate. If anybody has done a probate, you know they can drag, especially if there is a court approval needed. I have one going right now that's been in escrow 2 months, and we don't even have a court date yet. So that's how backed up they are. So um, court supervised probate if the paperwork is clean. So our job is to help set the table. We want to confirm authority. So is the right trustee in place? Do they have the power to sell? We want to confirm title. Is the property actually vested in the trust? And sometimes when you look at that prelim, you'll see it just kind of bouncing all over the place from, different family trusts and things like that. So we want to make sure that everything's been recorded along the way. So checking the title is really important on these. Provide the right names everywhere, as in Jane Smith, trustee of the Smith Family Trust, dated blah, 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 and get the trust certification early for title and escrow. When we lead this process, we protect timelines and keep buyers engaged. So, why else protect you and your client from avoidable risk? The most common train wrecks in trust sales are simple. The wrong person signs the listing or the purchase agreement. The home was never properly funded into the trust. Co-trustees or beneficiaries later object. Someone promises something the trust document doesn't allow. Each of these can kill or spark a claim. A simple intake routine can help avoid delays and other problems in escrow. Trust name, trustee identity, trust certification, title preview, and any consent requirements. Having an intake routine keeps the file defensible and your client protected. I can share this document later if you want in the Facebook group. I did just come up with a little intake form for taking a trust sale. Pricing and disclosure can be different. So, two quick nuances. Pricing expectations. Trustees have fiduciary duties. They're often focused on a clean, market-supported sale, not emotion. Your comps, condition strategy, and days on market plan matter even more because the trustee may need to document that decisions were prudent. Disclosures, standard disclosures still apply, but if the occupant never lived there, as in the property, such as a successor trustee selling after death, You'll pair statutory forms with an emphasis on third-party reports such as the NHD, inspections, prelim title, etc., and careful actual knowledge language. Being precise avoids misrepresentation and fills knowledge gaps ethically. Real differentiator with attorneys and fiduciaries. So estate planning attorneys, professional fiduciaries. I'm actually dealing with one of those right now on a different trust sale. And CPAs constantly field the question, who should sell the house in the trust? If you're the agent who speaks their language, doesn't overstep into legal or tax advice, and delivers clean checklists, timelines, and status updates, you'll become their go-to agent for referrals. That creates a steady stream of listings with motivated, organized sellers. All right, so what exactly is a trust? So a trust is a legal arrangement that allows one person or entity to hold and manage property for the benefit of another. Think of it as a protective box. The box holds the property, real estate investments, etc. Someone puts the property in the box, the trustor or the grantor. Someone watches over it and manages it, who is the trustee. Someone benefits from what's inside the box, which would be the beneficiary. Trusts are commonly used to avoid probate, protect privacy, and control how assets are distributed after death. Key parties in a trust, we have the trustor, the settlor, or the grantor. So who are they? The person who creates the trust and places property into it. What do? They decide the terms and who benefits and how the assets are handled. The trustee, who are they? The person or institution who manages the trust property according to the terms. And what do? They can sell, transfer, or lease property, but must act only in the beneficiary's best interest. And then the beneficiary, who are they? They are the person who benefits from the trust. What do? They receive income or property from the trust. They don't control the assets unless they are also the trustee. So an example would be the Johnson Family Trust owns a home and John and Mary Johnson are the trustees. They are the ones who must sign the listing agreement and purchase contract, not the beneficiaries or the trust itself. So main types of trusts in California. So here are the most common types of trusts you'll see when listing or selling trust held real estate. So revocable trust, created during the lifetime of the trustor or grantor, often called a living trust. Trustor actually retains control and can amend or revoke the trust at any time. Because the assets are still under the trustor's control, this structure avoids probate if properly funded, assets retitled to the trust, but does not provide strong asset protection from creditors. Real estate takeaway. So if property is held in a revocable trust, the listing can proceed much like a regular sale. The trustee, who is often the grantor, signs listing agreements, uses the trust name and company, and the title company relies on the certification. Irrevocable trust, once established and funded, the grantor gives up the right to amend, revoke, or control the assets in many cases. These trusts are often used for tax planning, asset protection, or real estate reduction purposes, or sorry, estate reduction purposes. These trusts are often used for, real estate takeaway because the property is now owned by the trust entity and the trustee signing authority may differ. You'll want to check the trust document carefully. There may be beneficiary consent requirements or restrictions on sale. Title deed review is especially important. So really, you're going to want to, in any of these trust situations, you're going to want to get title involved pretty early and get that trust certification and get those reviewed. Make sure there's no restrictions, proper people are signing. Testamentary trust, created through a will and only becomes effective upon the death of the creator, who is the testator. Because it becomes active through the will and often subject to probate, it does not necessarily avoid probate like a living trust. So the real estate takeaway here, if a listing is in this type of trust or the property is held in trust post-death, expect additional steps. Probate, estate filings, letters of testamentary, and possibly court involvement. Timeline may be longer and the authority less immediate. And specialized trusts, actually, my wife's grandparents had one of these. These include special needs trusts, charitable trusts, and other purpose-driven trusts. For example, a special needs trust is designed to hold assets for a disabled beneficiary while preserving their eligibility for public benefits. When you encounter a structure like this, know that the trust purpose may impose restrictions on sale, distribution of proceeds, or use of property. You'll need to dig deeper into the trust terms. So here's a little trust sales versus probate sales. Trust sales property is owned by a trust, managed by a trustee. The sale is handled privately outside of the court. The trustee has legal authority under the trust document to sell, and usually faster and simpler, similar to a standard sale. On a probate sale, property is owned by a deceased individual's estate, managed by a court-appointed executor or administrator. The sale is court supervised and follows California probate code. The executor administrator must often get court confirmation to sell, usually slower, can take months to court procedures. So the advantage of a trust at time of sale, faster timelines, lower costs because probate attorneys aren't cheap, more privacy, simpler for everyone, and better buyer confidence. When you're dealing with a probate and you're saying, well, this may take 3, 4, 5 months because we have to get a court approval on this sale, that can erode the confidence of the buyer that this sale is even going to happen. So, if you're talking to people and they don't have a trust set up or any kind of, way to convey their property upon death, maybe suggest they talk to an attorney to create a trust because it is much better for the family in the end than going through probate. The probate sale snapshot for comparison requires court-appointed authority. There's two main types of authority. There's the full authority under the Independent Administration of Estates Act, allows sale without court confirmation. And there's limited authority, requires court confirmation and often an overbid hearing. Longer timelines, typically 90 to 180 days. I'm experiencing this right now. That is pretty typical, especially if it is a limited authority. More disclosure, complexity, and strict statutory forms. Agents must use car probate listing addendum and probate purchase agreement, which is actually an addendum to the purchase agreement now. Legal and title considerations when listing a trust property, why this matters for agents. When a home is held in a trust, the listing process has legal and title risk you must account for. If you skip one step, such as verifying trustee authority or correct vesting, the transaction might delay, face title exceptions, or even fall apart. Authority to sell, so the trustee signatory. Confirm who the trustee is. Just don't take their word for it. You're going to want to, see that document. This person has the power to act on behalf of the trust. If the trust names successor trustees, ensure that the current one is correctly identified. Check the trust document or relevant excerpt for sale authority wording. Some trusts limit or require beneficiary consent for sale. On the listing agreement, always show the exact legal name in the correct trustee capacity. The example would be John Doe, trustee of the Doe Family Revocable Trust, dated March 15th, 2005 would be the example. This clarity helps avoid title issues or escrow holds. Review of the trust document and certification of trust. So a full trust agreement may not be required by title companies, but you'll often need a certification of trust under the California Probate Code. The certification should include key items: trust name and date, trustees' names, whether trust is revocable or irrevocable, trustee powers, especially to sell, and that the trust has not revoked, modified in a way that changes those powers. Pre-listing points for you: ask for a certification of trust early. If a successor trustee has been appointed, after death of original trustee, obtain trustee acceptance or similar document. If trust prohibits sale or requires all beneficiaries' consent, escalate with possible attorney involvement. Chain of title and vesting: verify the property's ownership vesting matches the trust or trustee. Deed should read the trust name or trustee's name in trustee capacity, not the deceased grantor. If incorrectly vested, title issues will arise. Ensure there are no intervening title conflicts. If the property was supposed to be funded into the trust but wasn't, you may see a deed in grantor name, then listing under trusting trustee. That's a red flag. Confirm that any liens or interests are addressed, and title company has clean as of date search showing trust ownership. Title insurance and additional requirements. Title insurance companies will often require certification of trust or trust excerpts showing trustee power to sell. So that should really be one of your first things on this listing appointment, especially after you get the listing, is, hey, I'm going to need a copy of certification of trust. So get that as soon as practical. Identification of the trustee, signing, it's not a bad thing to ask for identification. We should be doing that on basically everything. Proof of property and trust, and that there's no known challenge to the trust or trustee authority. As an agent, you should ensure the seller trustee is prepared for the title company's due diligence demands. This helps avoid closing delays. As a reminder, title insurance protects the buyer and often lender against undiscovered title defects. Clean documentation increases the marketability of the listing. And beneficiary rights and potential issues. The trustee has a fiduciary duty to the beneficiaries. If the beneficiaries are dissatisfied, as in the price is too low, the property wasn't marketed enough to get the highest offer, they might contest the sale. Your rule: standard marketing disclosures and professional service. Some trusts require the beneficiaries to be notified or consent before a sale. So again, you want to check the trust. So these are all things that can pop up, especially with the beneficiaries. They're the ones that can potentially derail the deal if they feel that they are not, essentially if the trustee has not done a good enough job with obtaining the highest amount for the beneficiaries. So that's why, they do have a fiduciary duty to the beneficiaries, just as you do to the trust when you're listing it. You want to make sure that you're covering all these steps as you go along to avoid things being contested. Might have had a question come up. All right, nope. All right. Listing process by trust type. So step by step for each trust scenario. So let's look at the revocable trust. A revocable living trust, meaning the grantor is still alive. Scenario: the homeowner or the trustor is still alive and serving as trustee of their own trust. We see this probably the most. What agents must check: verify that the property is titled in the name of the trust. Confirm the trustor and trustee are the same person. This is common for living trusts. Obtain a certification of trust. Confirm that the trust gives the trustee power to sell or convey real property. So step-by-step process, initial appointment, ask if the home is held in a trust and confirm the type, request documents, obtain the certification of trust, copy of the grant deed to confirm vesting, list the property, use the proper title and all the documents. Disclosures, since the owner is alive and occupied the property, standard TDS, AVID, SPQ, and NHD, all that stuff still applies. If someone's trying to tell you that they're exempt, in this scenario, they would not be exempt. Sale and closing, close normally. Escrow and title will verify trust authority, but no court approval is required here. This is the smoothest and most common trust sale. Treat it like a standard listing, but double check vesting and trust authority before inputting into MLS. Revocable living trust, grantor deceased. So here's the scenario. The trustor has passed away and the successor trustee now manages the trust. I'd say this is probably the second most common that we see. What agents must check, verify the successor trustee has accepted authority, written acceptance, or certification. You want to obtain death certificates of the deceased trustor or trustors, certification of trust, deed showing property vested in the trust. Confirm that the trust allows the trustee to sell assets post-death. Many of them do. Step-by-step process, initial meeting, ask, has the original trustee passed away and has the successor formally accepted trustee duties? Document collection, obtain certification of trust plus death certificates plus acceptance of trusteeship. Title verification, ensure title company recognizes the successor trustee and that property is vested in the trust. The listing agreement, you're going to sign as John Doe, successor trustee of the Jane Doe Revocable Trust. Disclosures, if the trustee never occupied the property, they only disclose known facts. Many fields in the TDS SPQ can be marked unknown. Close of escrow, title and escrow will require copies of trust-related documents. No court confirmation is required. Explain to the trustee that the sale proceeds go to the trust, not directly to the heirs, until the trust distributes them. Let's see. Next up, irrevocable trust. Scenario, the trust cannot be changed or revoked. Control belongs to the trustee, not the grantor. So what agents must check? Confirm who the acting trustee is and whether beneficiary's consent is required to sell. Review the trust language carefully for sale or distribution authority. Obtain certification of trust and possibly attorney confirmation if trust terms are restrictive. Step-by-step process on these ones. Trustee verification. Again, we're obtaining the certification of trust with clear authorization to sell. Some irrevocable trusts require written consent from all beneficiaries, so you want to review that. Listing agreement signed using full trustee capacity. That would look like Mary Johnson, trustee of the Johnson Irrevocable Trust. Disclosures, if no occupant knowledge, mark unknown, but still disclose material facts known by the trustee. Escrow title coordination. Title will carefully review the trust powers and may request legal opinion or attorney letter confirming sale authority. Expect longer title review and more paperwork on these. Always confirm the trustee's authority before going live on the MLS. Testamentary trust created by a will after the grantor's death and administered through probate sale. What you must check as an agent, confirm that probate has been opened and the court has issued letters, testamentary or letters of administration with will annexed. The executor trustee's powers to sale must be authorized either by the will or by the probate court. Court confirmation may still be required unless the trustee executor has full authority under the Independent Administration of Estates Act. Step-by-step process on these: verify probate status, request copies of the will, court appointment, and authority letters. Work with the attorney, coordinate with the estate attorney on court timelines and sale authority. The listing agreement you're going to sign as Susan Miller, executor and trustee under the last will and testament of Robert Miller, deceased. Marketing the property, disclose in MLS that the sale is subject to court confirmation if limited authority applies. You can just ask the attorney on that if you're unsure. They will let you know. Disclosures: executors complete limited TDS SPQ to the best of their knowledge. Closing may require court confirmation hearing. Escrow will coordinate with the attorney. These sales often take longer. Prepare buyers for possible overbid hearings and 60 to 90-day plus timelines. So you want to, set that tone early in these transactions. And sometimes the best offer is the buyer that's going to stick around. So it may not be the highest, but if they can't wait more than 2 months, because their lease is ending or whatever they have going on, that might not be the right buyer for this type of sale. So let me just check in here. Yeah. I'm going to put this in the Rise Realty Facebook group under the recording a little later today, so you'll have access to this document. So marketing disclosure issues specific to trust properties. So what to know when advertising, disclosing, and explaining trust sales. So advertising and representation rules. Trust sales must be marketed truthfully without misleading the public about ownership or authority. Agent responsibilities: disclose the nature of ownership. Always note trust sale and MLS, flyers, and online marketing. This signals to the buyers that a trustee, not an individual owner, is selling. Do not identify beneficiaries or family details. Avoid statements such as the home is being sold by the children of the deceased. Those details can violate privacy and invite disputes. Use correct entity language, MLS entry, so trust sale, property held in Smith Family Trust. Trustee has full authority to sell without court confirmation. This would be like in the private remarks. Never advertise or imply the sale is a probate unless it actually requires court supervision. Verify authority before publishing. Advertising a property for sale before verifying trustee authority could expose the agent and broker liability. Broker identification, include broker's name, DRE. We all know this one. Disclosing trustee status. Under California Civil Code, trustee must make the same statutory disclosures as sellers to the extent of their actual knowledge. Key disclosure points: trustee signs the TDS, the SPQ, even if they never lived in the home. Trustee may answer unknown where applicable, but they must still disclose known defects or material facts. Listing agent must complete their agent visual inspection. This duty does not change in a trust sale. Add a trust advisory to the file. It clarifies the trustee's limited knowledge and the buyer's due diligence duties. Disclose if the trustee is also a beneficiary. This may also change fiduciary obligations or negotiation dynamics. Make sure all parties understand that the seller on the contract is the trustee, not the individual family members or heirs. Buyer perception and marketing benefits. So understanding how to market trust sale properties effectively can help agents highlight their value while setting realistic expectations. Benefits for the buyers and sellers. Again, typically faster, transparent title. So trustees provide clean title through certification and title insurance. Less emotional negotiation. Trustees act in a fiduciary capacity. Sales tend to be business-like and efficient, often an as-is condition. Trustees usually sell without making repairs. Buyers see this as an opportunity to customize or invest. Risks or buyer concerns. Limited property history. Trustees may have limited knowledge about the property conditions, systems, or improvements. As is nature, repairs or credits are less common. Disclosure gaps. Buyers should perform more thorough inspections to offset trustees' limited knowledge. You're going to want to advise your buyers this when you're going through one of these sales with limited disclosures. On the listing side, you may want to encourage the buyer's agent to, have their clients do it or get inspections done on the property. Set expectations early. In your buyer remarks, emphasize trust sale. Trustee has never occupied the property. Buyer to conduct all desired investigations. IRS capital gains and cost basis considerations. While agents cannot give tax advice, understanding the basics helps you communicate intelligently with clients and refer them to professionals. Common tax issues and trust sales, step up in basis as at death. When a property passes through a trust after the grantor's death, the tax basis typically steps up to fair market value at date of death. Benefit reduces or eliminates capital gains on immediate sale. Revocable trusts become irrevocable upon death. Once the grantor dies, the trust is no longer disregarded for tax purposes. Proceeds belong to the trust, and tax reporting may shift to the trust's EIN. Irrevocable trust sales. Capital gains may be higher if the trust basis is not stepped up or if the trust was funded long ago. Encourage trustee to confirm basis with a CPA or a state attorney before listing price decisions. Trustee's obligation. Trustee must ensure sales proceeds and tax liabilities are properly reported under the trust's EIN, not their personal socials. When asked tax questions, say that's a great question for your CPA or tax attorney. Every trust tax treatment is different. We'll make sure escrow provides all the documents your accountant needs. So transaction escrow procedures and for trust, this is some of the stuff that escrow is going to be looking at, things they're going to be wanting from you. So handling contracts, documentation, and proceeds the right way. Trust sales can look similar to standard transactions, but they involve distinct legal signatures, escrow documentation, and distribution procedures that agents must handle carefully to protect both the trustee and beneficiaries. Contract basics and special considerations. Who signs? We've gone through this. The trustee signs on behalf of the trust, not the individual owner. So make sure you have the correct trustee and have it spelled out correctly as well. Never allow beneficiaries or relatives to sign unless they are also acting as trustees or are legally empowered by the trust document. Double check trustee capacity, name spelling, match the certification of trust and vesting deed. Contract preparation, use the most current car residential purchase agreement and include the trust advisory. Identify the seller properly. Do not list beneficiaries in the purchase contract. Add remarks under other terms such as this is a trust sale. Trustee is not occupied property and will provide disclosures based on actual knowledge only. Escrow documentation and verification. So what they're going to be requesting from you, and you should be gathering or putting, the trustee in contact with escrow directly. Escrow officers play a vital role in verifying trustee authority, ensuring title can transfer correctly. What they're going to ask for is certification of trust, death certificates, trustee's acceptance of duties, copy of grant deed, trustee ID verification, and possibly notarized signature. The agent's role, submit all trust documents to escrow within 48 hours of acceptance. Communicate early with escrow title about whether beneficiaries must consent. Confirm escrow has trustee contact information, not the beneficiary's contact information. Escrow cannot proceed if trust documentation is incomplete. Always pre-collect these before going live on MLS. So look for these 5 things as applicable, so that you know when you open up escrow, you're not going to, well, at least hopefully not run into any snags that can prevent the sale. Timing and deadlines. So trust sales can experience small timing differences, review periods. So trustees may need longer to gather paperwork or beneficiary consent, especially on the beneficiary consent. We had one many, many years ago, where they couldn't find the beneficiary and they needed his consent. And so um, you can imagine, how fun that is. So basically that property just, it couldn't sell until they got that sorted out. Contingency periods, keep the standard buyer timeframes, inspection, loan, appraisal, but build a small buffer in case trustee review or document verification takes extra time. Close of escrow, proceeds are paid to the trust, not to the individual trustee. Example clause to include under additional terms. Trustee requests minimum 5 business days after contingency removal to complete internal trust documentation and distribution authorization. Proceeds distribution. Sale proceeds are payable to the trust account, not the trustee. So if you've, for some reason, a beneficiary is calling you saying, "Where's my money?" It's going to go into the trust account. Escrow will issue proceeds to the Smith Family Trust dated March 10th, 2010, unless otherwise directed in writing by the trust attorney or CPA. After closing, the trustee handles distribution to beneficiaries per the trust terms, not the agent or escrow's responsibility. If beneficiaries ask about their share, politely explain that the funds are distributed through the trust and the trustee or attorney will handle that process. So just direct them over to the proper people. Beneficiary consent and disputes. Depending on the trust type, some sales require written consent from beneficiaries. Irrevocable trusts may need unanimous beneficiary approval before selling. Multiple successor trustees all must sign the listing and sale documents. Testamentary trusts, court confirmation or attorney direction is required. If one beneficiary objects, pause marketing or escrow until legal authority is confirmed. Consult the trustee's attorney before proceeding. Warning, proceeding with a sale when authority is unclear can create liability for both the agent and broker under the civil code, which is a breach of fiduciary duty. Navigating contingencies, so inspection contingencies. Again, trustees rarely perform repairs. Usually we see this more when the trustees, grantors have deceased, and now the kids are the beneficiaries, and they don't want to deal with the house. They don't want to deal with repairs. It's emotional for them, all of these things. So we do see a lot of as is. And, we all know all contracts are as is. So what this is alluding to is they're probably not going to be willing to make repairs on the house. Encourage buyers to perform full inspections early. If the trustee agrees to repairs, require written beneficiary or attorney approval. Loan and appraisal contingencies. Standard timelines apply, but escrow may delay until trust documents are verified by title. Communicate proactively with buyer's agent about expected verification steps. Title contingency. Title may take extra time to confirm trust vesting. Order a prelim. As soon as you list, don't wait for escrow opening. And so you can get them working on that early. Looks like we might end up, yeah, about 10 minutes late we'll run. So risk management for agents and trust sales, avoiding pitfalls and protecting yourself and the brokerage. When listing or selling property held in a trust, agents must balance diligence with sensitivity. While trust sales often move faster than probate, they carry unique legal, title, and disclosure risks. Failing to manage these can lead to commission disputes, E&O claims, or even license discipline. Some common pitfalls, incorrect trustee authority. What happens? The person signing the listing or purchase agreement isn't the legally authorized trustee. Why does that matter? Sale could be void or delayed. Title insurance may refuse coverage, and escrow cannot close. How to avoid it? Certification of trust. So I think we've said that word probably 10 times. Make sure you get that and verify before putting it into the MLS. If there are co-trustees, all must sign unless the trust explicitly authorizes one to act alone. Missing or incomplete trust certification. What happens? Title of escrow cannot verify the trust legitimacy, delaying or halting closing. How do you avoid that? Request a certification of trust at the listing appointment. Review that. It includes full name of trust, date of execution, trustee names, statement of authority to sell. Submit it with your listing paperwork and to escrow immediately upon opening. Title investing errors. What happens? The grant deed does not match the trust name or title has not yet been transferred into the trust. How to avoid that? Verify vesting early with a preliminary title report. If the property is not in trust's name, the trustor must deed it into the trust before listing. Coordinate with title, confirm the trustee's exact name exactly matches the deed. Never assume, check the actual vesting deed. Beneficiary disputes, what happens? The heirs disagree with the trustee's decision to sell or terms of sale. Why does this matter? Escrow can be frozen, lawsuits can be filed, or buyers may walk away. How to avoid it? Ask if all beneficiaries are aware of and agree with the sale. Recommend the trustee communicate in writing with all heirs before listing. Document any disputes reported to you and notify your broker immediately. Incomplete or incorrect disclosures. What happens? Trustees fail to disclose known defects, or the agent forgets to complete the avid. How to avoid it? Trust must disclose known material defects. The agent's duty of visual inspection never changes. Always use the trust advisory form with your contracts. When in doubt, disclose in writing. Basically, nothing changes there. Best practices to protect yourself and the brokerage. Verify before you list. Again, certification of trust, death certificates, trustee acceptance or appointment letters, grant deed showing the vesting. So get those 4 things. Confirm that the trustee has explicit power to sell real property. Use the proper forms, naming conventions. So we want to list them correctly in the listing agreements. Use all the usual forms we do in the standard sales, except add in the trust advisory form. Keep the broker informed of beneficiary or family disputes, title or vesting discrepancies, escrow delays due to missing trust documents. Obviously, we're required to supervise these, so involve us early. Communicate clearly with escrow and title, provide escrow with all trust documents up front, confirm that proceeds are payable to the trust, not individuals, avoid giving tax or legal advice, refer clients to the professionals. And document everything. I mean, this should be just common practice with all of your listings and sales, but keep a written record of client instructions and conversations. Copies of trust documents submitted to escrow, buyer inquiries about condition or authority. Upload all communication and documents to your online transaction portal within 48 hours. Well-documented file is your best defense in an E&O claim. So again, this goes for all files, but you know, if you are documenting properly, documenting your marketing efforts, things like that. When these beneficiaries, if they do, um, dispute this, or they contest it actually, you can you have proof of what you've done and how long it's been on the MLS and all the exposure it's gotten. So that way that can hopefully be debunked. Manage the expectations, educate the buyers and sellers about what makes trust sales different. Trustees often have limited property knowledge. Repairs and credits are rare. Timeline may take longer for document verification. Setting these expectations early prevents misunderstandings later. I just do that with basically every file I'm working with, whether I'm on the buy side or the list side. I like to set the expectations pretty early. It really helps make deals flow much smoother. Lastly, when to escalate or seek legal advice. Agents are not attorneys, should never interpret trust language or court orders. Escalate immediately if the trust language about selling property is unclear. Multiple beneficiaries disagree about selling. Title report shows conflicting ownership or liens. The trustee requests to change names or ownership mid-escrow. Contact your broker and or refer the client to the estate attorney or CPA before proceeding. And then E&O and liability reminders. E&O covers you only if you act within your license authority and report potential claims promptly. Common question comes up with E&O, what about the sellers? Well, with us having E&O insurance through CRES, there are a few ways. We send out reminders of this every month to provide your clients with a little bit of protection. If they get a certain, NHD that is a CRES policy or a home warranty that is a CRES policy, those can add some extra coverage for your sellers too, should a claim arise and they need attorney's fees. So fraud, negligence, or acting outside the scope of authority voids coverage. That's on not just trust sales, that's on all sales. Always follow the brokerage's risk management and claims policy procedure policy, report issues and writing to the broker immediately, which everybody's pretty good at doing, and I appreciate that. So I'm gonna wrap this up. So yes, I am going to, so if you're in the Facebook group, the Rise Realty private Facebook group, when we post up the recording, I'll put a link for this document as well, so you can just have it handy. Probably good reference material if you have a trust coming up or one comes up in the near future, you can use this. And it also has a link over to the intake, just to kind of help you know what documents you should be getting and a little bit of process there. So thanks for attending, everyone. Hopefully you learned a little bit today. I learn when I do these as well. I do end up having to do some, quite a bit of research to put together a lot of these meetings. But I think they're beneficial for everybody. So I do appreciate you joining in on Mondays. So if you have any questions on anything, always give us a call. And otherwise, I hope you have a great week, and we will talk to you soon.